So the Supreme Court is considering an emergency application against New York's new concealed carry law that also put in place ammunition restrictions. So let's talk about this. But real quick before we jump into this video, if you think restrictions on ammunition and their purchase is clearly unconstitutional, go ahead and hit that like button and subscribe. Also want to make a quick announcement. A lot of you guys are familiar that a couple years back we did the Armed in May event in San Bernardino at Route 66 Shooting Sports Park. This year they're going to be holding their annual Range Expo. I'm going to be attending again. Reno May is going to be there. I believe Mike Glover's going to be there. And it's always an amazing time. I'm glad I get to come back this year and get to share it with you guys again and meet you guys again. The event's going to be taking place on October 7th through 8th. I will leave a link down below to Route 66 and their website. You do need to RSVP because there's going to be limited space and you need to essentially reserve your spot. So again, I would love to see so many of you guys out there. It was so much fun the last time we got to do it. And again, I'm really looking forward to it. There's going to be a ton of vendors and all the proceeds for the event go directly to two-way organizations that are fighting for our rights here in California. I believe last year they raised about $70,000 for CRPA and then also FPC. So it would be amazing if we could up that number, get more attendance this year, and also raise more money for the two-way cause here in California. So again, link's going to be down below, and I would love to see you guys there. As I mentioned in the intro, in this video, we're going to be discussing a challenge to New York's new concealed carry law, the CCIA, and also some of the ammunition restrictions that they put in place through that law. The case we're going to be talking about in this video is called Gazzola v. Hochul. This case involves a challenge to the state of New York's new CCIA law, which was passed in direct defiance to the Supreme Court's recent decision in New York State Rifle and Pistol Association versus Bruen. More specifically, the current emergency application that's in front of Justice Thomas in the Supreme Court has to do with the new ammunition restrictions that were put in place through the CCIA. The Gazzola case focuses on the impact that the CCIA specifically has on gun dealers and then also purchasers of ammunition. These businesses argue that the CCIA is unconstitutional because it violates the Second Amendment and also the Supreme Court's recent decision in Bruen. The businesses argue that they are a critical component to the right to keep and bear arms and that the CCIA attempts to regulate them out of existence along with putting in place unconstitutional restrictions on the purchase of ammunition. This whole lawsuit sprung up as a result to the Supreme Court's recent decision in Bruen. In Bruen, the Supreme Court struck down New York's May issue CCW licensing scheme, finding that it was inconsistent with this nation's history and tradition. One of the primary findings of the Bruen decision was that the government bears the burden to prove that their restrictions are based in the history and tradition of our nation. However, despite that decision, New York rushed through the Concealed Carry Improvement Act, also known as the CCIA, which made the permit scheme even worse than the one that existed prior to Bruen. In this case, the plaintiffs originally sought to obtain a temporary restraining order and also a preliminary injunction. And the federal district court on review rapidly denied both the TRO and also the injunction. The court issued the denial without even holding a hearing, and then the plaintiff decided to submit an interlocutory appeal up to the Second Circuit. The plaintiff sought for the Second Circuit to find that the prior denial by the district court of the TRO and also the injunction was in fact an error. However, the three-judge panel in the Second Circuit originally denied their appeal, saying that the court weighed the applicable factors and found that the district court was correct. In response to that original denial, the plaintiff submitted a petition for a writ of cert before judgment to the Supreme Court. This is an interesting mechanism to seek early Supreme Court review of a case. This type of petition invokes the Supreme Court's statutory power to grant review of a case before a lower court actually reaches a final determination. Ultimately, what ended up happening is that the Supreme Court denied the writ of cert before judgment. Instead, what the Supreme Court indicated in some of the other cases is that the Second Circuit needed to decide the appeal quickly. They needed to review the entire issue, and if they didn't, then the plaintiffs there could come back to the Supreme Court and seek a new review. This is all based on the Antonyuk case, which was the GOA-driven case. I will leave links to them below if you want to support GOA. GOA brought a lawsuit to CCIA at large. They challenged the lawsuit at large in the Antonyuk case. It made its way to the Supreme Court on an emergency application. Justice Alito and some of the other judges denied the emergency application, but Alito did write a dissent or some opinion in it stating that the Second Circuit needed to review all these cases dealing with the CCIA fast. And if they didn't, then of course the parties can come back to the Supreme Court. Now, in March, all 5 cases involving the CCIA, including Gazzola, were argued before the Second Circuit. But since then, we've heard almost nothing from the Second Circuit and there's been no decision. In the meantime, the state of New York has put in place the ammunition background check system, which took effect on September 13th. That fact and the inactivity of the Second Circuit led to the plaintiffs in Gazzola once again going up to the Supreme Court seeking an emergency application and emergency relief. The Gazzola plaintiffs filed an emergency application for a reversal of the injunction denial, and also they are seeking an administrative stay. What this means is that there is an emergency application sitting in front of the Supreme Court asking them to halt the New York ammunition background check system that was put in place through the CCIA. The emergency application was originally filed to Justice Sotomayor, who is the justice responsible for hearing emergency applications that come out of the Second Circuit. That emergency application was originally filed on September 11th. The hope was to get the Supreme Court to step in and grant an administrative stay before this ammunition background check system took effect. Sotomayor, as the justice responsible, had the ability to either grant or deny the application on her own. However, recently and most traditionally, what ends up happening is the justice responsible then refer it to a full court for consideration. But interestingly, the next day, Justice Sotomayor denied the application. Now, why this is such a significant issue is because the ammunition background check system is not working at all in the state of New York. There are reports that multiple individuals, police chiefs, judges, a ton of individuals are being denied the background checks in relation to ammunition purchases. So it's not really being effective, and also I believe the system crashed when it initially went up. Now, after Justice Sotomayor denied the application, that then led the Gazzola plaintiffs to refile and resubmit the application to Justice Thomas. Under the Supreme Court's rules, once the responsible justice denies the original application, the plaintiffs in the case can then submit it to any justice that they want. And of course, they chose Thomas because he's the one who authored Bruen. And recently, a docket entry popped up indicating that the Supreme Court will in fact hold a conference in this case, and that will take place on October 6th. Now, I will say that it's probably not a great sign that Justice Sotomayor denied the application on her own. Again, the justices will typically refer these requests to the full court. From the docket entry and the set conference, the indication is that Justice Thomas has sent it to the full court for consideration. I will also note that the last emergency application for a stay that went up to the Supreme Court did not go in our way. It was not in our favor. It did not go the pro 2A way. Recently, you had the ATF go to the Supreme Court and ask them to stay the decision against the frames and receivers rule in the Vanderstock case. And in that decision, Justice Roberts and Barrett joined the liberal justices to grant the ATF the stay that they were asking for. So recently, the Supreme Court has granted an emergency stay, but it was in favor of the ATF. So I'm not saying that this will 100% be denied, but I am thinking that this is pretty much just a Hail Mary, and the likelihood is that the Supreme Court will continue to deny review on some of these issues until the Second Circuit actually decides those appeals. The Second Circuit has been sitting on those decisions for a very long time, but there are a lot of cases. I believe there's 5 CCIA cases that they're going to decide. So they can kind of lean back on that and saying, hey, that's what's taking us so long. However, if the Supreme Court did grant a stay on this issue, that does bode very well for some of these other cases, especially other ammunition challenges like the Rody v. Bonta case that's taking place in California. Recently, Judge Benitez requested additional information from the parties on the constitutionality of the similar background check system that's in place in California. So all that information is being submitted to him. Then he's going to decide that case. But a Supreme Court stay of a similar scheme in New York would pretty much very much help the injunction request that's being sought in California. Because if the Supreme Court is seeing that the ammunition check system in New York is so bad and so unconstitutional that an administrative stay needs to be granted, that would mean that a similar stay should be granted or a similar injunction should be granted in California. So now all eyes will be on the Supreme Court to see what they're going to do with this ammunition background check system and this emergency application that's in front of them and is seeking emergency relief. If anything else develops, of course, I will let you all know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. As always, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.